Antes de darmos início ao evento, gostaríamos de reforçar o seguinte disclaimer. As manifestações expressas por integrantes dos quadros da Fundação Getúlio Vargas e por convidados que participam dos eventos e transmissões online representam exclusivamente as opiniões dos seus autores e não refletem, necessariamente, a posição institucional da FGV. Após este vídeo de aviso, solicitamos a autorização para o uso da imagem e da voz dos palestrantes mediante manifestações de concordância, tais como um aceno de cabeça ou outro gesto de aprovação. Agradecemos sua participação e desejamos um excelente evento.
Hello, good morning, everybody from a cold Rio de Janeiro. My name is Nicolas Zingales. I'm a professor at FGV Law School here in Rio and head of the e-commerce research nucleus, as well as researcher at the Center for Technology and Society, where I coordinate 2 projects on platform governance that are relevant to our conversation today. I have the pleasure to welcome you to this webinar that is entitled Interoperability in Digital Platforms and its Regulation, a Transatlantic Dialogue. And I think this topic is particularly timely, at least because of 2 reasons. One is that we are witnessing a growing number of cases relating to interoperability in digital markets being brought by competition authorities all over the world, and including also some recent developments in Brazil. And then a second reason is that we are about to see a bill being introduced into Congress in Brazil regulating digital markets from an ex-ante perspective, which would facilitate interoperability and would create this dialogue with other jurisdictions on various bills and legislation that are being proposed to achieve the aim of fostering open and competitive digital ecosystems. So today I'm joined by a stellar group of scholars, experts, and partners that discuss with us these topics over the last few months and years, it's definitely going to be an exciting conversation. The idea was precisely to bring together people from different jurisdictions to show how this is a topic that is attracting increasing attention and where the conversation across jurisdiction is building like a really growing corpus of insights that can be shared and nurtured across jurisdictions. So let me start by introducing to you the speakers that we will have with us today. First, we will give the word to my colleague Fernanda Martins, who is a researcher with us at Center for Technology and Society at FGV. She will present the results of a project that we have been developing with students at FGV that produced some comparative infographics on regulation of digital platforms, particularly from an ex-ante perspective, and with a focus on interoperability measures that can be advanced through this regulation. After that introduction, we will give the word to Ravi Madruga, who is director at the Secretariat of Economic Reform of the Ministry of Finance, and he will provide us some context on the recommendations that the Ministry of Finance sent to the government on enacting an ex-ante regulation or reforming digital markets. And so we're going to hear from him about these proposals. Then we were supposed to have Commissioner Camila Alves Cabral with us, or her chief of staff. At the moment, we are not having them yet. Let's see if...
I'm here, Nicolo, sorry.
Perfect. Okay, so we have now also Victor Jardim
Sorry
Barbu.
for the delay.
No problem. And we are very happy to have you with us. And so Victor is the chief of staff of Commissioner Camila at CAGE, and will present to us a view on what we've learned with the analysis of digital platform markets in Brazil. After this first introduction that pertains to the Brazilian context, we will break already with some Q&A. So at this point, we are happy to receive any questions, suggestions, particularly on these three contributions. And here we will, after breaking up for this Q&A, we will move to the next segment, which will move to another continent. We will land in Europe, Europe and the UK. Europe in a broad sense, so not European Union only. We'll start with Simonetta Bessoso, who is a professor at the School of Economics and Management of the University of Trento, and also curator of the fantastic blog Competition Wave, which I highly recommend. There's a lot of content on law and technology. Then we will have Maria Luisa Stasi, who is the head of digital markets at Article 19 in London, and a great partner of civil society with us on a lot of these discussions and initiatives. So she will present some view on interoperability, particularly in the social media context. Then after that, we will move to Ian Brown, who is visiting professor with us at CTS, Center for Technology and Society, a computer science expert that understands the law much better than many lawyers, and is a passionate and prolific author on interoperability. And I don't know if I would put him into UK or EU or Brazil, but he is part definitely of this global conversation on interoperability. Then we will break again for a short Q&A about this segment, and then we'll move to the last part, where we start hearing from Chief of Staff Bruno Renzetti, who's also professor at INSPER and Chief of Staff with Commissioner Carlos Jacques at CAGE. And he has been closely following the developments of digital markets in Brazil and worldwide, and will talk to us about the prospects of regulating cloud computing services, which is an aspect that has not been addressed, let's say, to the full extent in the Digital Markets Act in the European Union. So therefore, there's a lot of potential for discussion on this topic. And finally, we will move back to our Center for Technology and Society, giving the word to Arthur Sadami, who is a researcher with us there. Although unfortunately is about to leave us to go to Yale for an LLM next year, where we hope that he will build more bridges that will enable us to continue this global conversation on digital markets regulation. So this is indeed, as I mentioned, the goal of our discussion today, showing that digital markets regulation is something that is a need perceived across jurisdictions. And this is particularly due to the challenges posed by digital platforms and ecosystems more broadly. So this is becoming really a transversal topic, particularly looking at how we can open up these ecosystems and maintain them competitive over time. So in that line, we consider that interoperability is an illustrative measure that can be looked at as a core of these ex-ante laws or reforms of digital markets that have been introduced. But I wanted to just briefly preface that discussion by illustrating very briefly how we are conceiving of digital markets regulation and interoperability. So I'm going to share briefly the slide. So here you can see different writings. One was by our colleague Ian Brown, that already in 2020 published about interoperability as a tool for competition regulation. I think at the beginning, the conversation on interoperability was more focused on technical aspects of interoperability. At the very early stage, the discussion was really about interconnection and how to facilitate it. Progressively, it has moved into something more sophisticated, like semantic interoperability, how to enable not only that systems interconnect, but also that they can speak to each other in a meaningful way. And more recently, there was, I think, this very enlightening paper written by scholars at Yale with the Arnold Truman project, that they talked about equitable interoperability as the super tool for digital platform governance. And what they use here is the concept of interoperability in a broad way, which means basically giving to the entrant in a digital platform ecosystem equal treatment. It's not just about interconnecting, it's not just about meaningfully talking to each other, but really giving the same treatment in order to enable competitive digital ecosystems. So we also, my colleague Luca Belli, applied this concept to the BRICS and reviewed some of the developments that are relating to the last few years in the BRICS. There was also a report published by CADE at the beginning of last year that reviewed the development in digital markets in the BRICS, and definitely interoperability, both in the cases and in the proposals that we have seen coming forward, has been an important dimension. You might have seen that there was a bill in Brazil that already discussed the idea of ex-ante regulation, basically borrowing some concepts of the digital markets up in Europe, and the obligations were rather high level and non-specified, but at least a couple of those could be considered to link to the concept of interoperability, in particular when we talk about non-discrimination and not refusal to deal with professional users. And the authority that was initially designed, tasked with enforcement of this act, would be the telecom authority, that has a lot of experience on interoperability, interconnection between telecom systems and components. But there was a concern that maybe this authority would not be the best placed to implement broader types of interoperability in the sense that we are discussing today. So the last version of the bill, the last episode in this saga, it was the proposal by the Minister of Finance, which recommended a different approach to digital markets regulation, which we will hear about. But I just wanted to conclude to say that this is a conversation that is not focusing just on the platform as an isolated player in the digital space, but it's bringing together the whole range of actors that operate on top of the platforms. And this is the concept of ecosystem, digital ecosystem, that has started to become more and more central to the analysis of CAGE and in digital markets discussions. Also, thanks to the BRICS, the discussion in the BRICS, UNCTAD, that has promoted this discussion. We are also hosting every year a BRICS Plus Digital Competition Forum that promoted this idea of ecosystems. And so I think this concept of interoperability links very well with the idea of promoting open and competitive digital ecosystem. So with that very brief introduction, I now want to pass the word to my colleague Fernanda, that will give us a snapshot of the different proposals that have been made around the world on ex-ante regulation, including at least 2 jurisdictions in which the law was already enacted, like the European Union and the UK, and will show us the potential of talking about interoperability in this context. So Fernanda, thank you very much, and you have the floor.
Thank you very much. Can everyone hear me well? Yes?
Yes.
Okay. So, good morning or good afternoon to all. I will present my slides to my presentation here. Just a second. It's okay?
Yes.
Yeah, okay. So, like Professor said, I'm Fernanda. I'm a researcher at Center for Technology and Society at FGV. And like Professor Nicola was saying, we, in this first semester of 2025, we carried out this project at FGV. It's Field Project, the name. And we involved a team of 11 undergraduate students. And the project was coordinated by Professor Nicola, and I had the pleasure to supervising the students throughout this process. And moving straight to the project itself, we focus on mapping and comparing global initiatives to regulate competition in digital markets. So we analyzed 14 laws or legislative proposals across 10 jurisdictions, and each student worked on one jurisdiction and applied a common set of 23 criteria to structure the analysis. So we, considering these 23 criteria, we generate a comparable data set across these 10 different jurisdictions. And this was our methodology, right? We first conducted this individual legal analysis, so each student conducted its own analysis of the law or the proposal. And we organized this data into a big spreadsheet, considering that 23 criteria. And this is our main project database, this big spreadsheet. And then after this, we create some variables to allow this cross-country analysis, because we couldn't compare them so easily, just looking for the, oh, sorry.
Sorry to interrupt. It seems that your audio is not coming out that strong. If you could speak closer to the microphone,
okay,
or there, that would help.
Okay, thank you.
Thank you.
So after this big spreadsheet with all the copy and paste articles of the proposals or the legislation, we create some comparative variables to allow this cross-country analysis, because laws are have some different ways to say the same things. So we choose these comparative variables to create some a new spreadsheet, right? So we create a Google form, and then we generate a new spreadsheet. And with this new spreadsheet, we used to produce some charts that I will show you as our product of this field project. So this was the two first charts we reproduce. This first one shows that most jurisdictions, 8 out of 9, have adopted ex-ante regulatory approach, and this only one jurisdiction is Germany, because Germany combines ex-ante duties with obligations that also depend on market behavior, because the regulation is not separate, it's just an amendment to the Competition Act. It's section 19A. So this is German. This only jurisdiction is Germany. And more recently, it's nice to say that South Korea joined Germany by proposing a reform of competition law, but this proposal is still pending. And according to our research, this seems like unlikely that this proposal will go ahead. Actually, the current government seems more inclined to go ahead with the ex ante law, or I mean ex ante proposal, because so we did not consider this this reform of competition law in our analysis. It's just the ex ante proposal. So we can observe about this first graphic that it's a notable trend toward a preventive regulation in digital markets. And so the second chart regarding designation criteria of this ex ante regulation, we can see that 6 out of 9 jurisdictions use both qualitative and quantitative criteria to designate digital platforms, and fewer rely on only qualitative or only quantitative criteria. Né? So we can see that it's a preference for a more balanced regulatory approach. And just a little disclaimer here: our project covered 10 jurisdictions, but the United States was excluded in these graphics because we analyzed 5 different legislative proposals in United States, and that are still under discussion. So just to not to ensure the consistency of our work, I mean one law or proposal per jurisdiction, we limited these charts only the nine countries, and we exclude United States from this comparative charts. So moving to the next chart, this third shows that most commonly used qualitative factors across jurisdictions are market power and economic dependency and bargaining power, because this two was cited by 8 out of 9 jurisdictions. And I think this reflects that market power still plays an important role, but is associated with another factors. The first one of which is related to the concept of dependence. Because this concept can manifest itself well beyond the traditional analysis of the market, like a unit concept. So it is an important finding that we have about this chart. And among quantitative criteria, it is easy to see that some jurisdictions focus on local or national turnover, and others focus on global turnover. And we can see that the global presence can be a factor that strengthens the financial powers and ultimately the economic power of these firms, because this was the 2 most quantitative criteria that appears in our researches. Moving to the next charts, we are talking about fines here, and all the 9 analyzed jurisdictions that we're talking about here provide the imposition of fines for violations. And considering this, these fines vary across jurisdictions, but the most commonly fall within the maximum of 5 to 10% of a specified financial base. And this financial base, right, the predominant basis for calculating these fines is the global turnover or revenue, because we found like 5 out of 9 jurisdictions using this as a basis for amount fining. So we can note that only 1 jurisdiction focuses specifically on the benefit derived from the infringement as a basis for the calculation of fine, because it's like a fixed amount, right? So this global turnover is the most predominant basis amount. And moving to remedies, we did this analysis about behavioral remedies and breakup or structural remedies, and we find that 7 out of 9 jurisdictions leave some discretionary powers to the enforcement authority to define the best behavioral remedies without an exhaustive list in the regulation. So we have some lists on the regulations, but we see some regulations that leave this space for the authority to impose the best behavioral it thinks it would be best to that specific conduct. So, and regarding breakup or structural remedies, we can see that the majority, like 6 out of 9 jurisdictions, answered no, indicating that the law does not provide breakup or structural remedies. And 2 jurisdictions responded that breakup or structural remedies is a possibility, but only as a last resort. So only if the behavioral remedies did not work. And just one jurisdiction is explicitly establishes the structural remedies as not as a last resort. So this suggests in our analysis that breakup or structural remedies are generally considered a measure of a last resort under law, and fines are more important for the enforcement of infringements of the law. So this graphic, I cannot explain everything to you, but it's we did some classification of the types of services that are covered by each law, each regulation. And we can see that online search engines, online social network, video sharing platform services, and operating systems are the most predominant types of services that are covered by these 9 regulations that we analyzed. And this one, I've just explained that this is one not applicable or not mentioned. It's about South Korea because we did not have access yet to the draft of South Korea ex-ante proposal. So we cannot know the types of service that will be actually covered by the law. And oh yes,
in a minute or 2, that'd be great.
Okay. So this next charts, it's like all the binary responses, like yes or no. So I think it's very clear here that we have regarding responsive approach, I mean a possibility of negotiation or adjusting the conduct before adopting the infringement decisions. 6 out of 9 have this possibility. And regarding concentrations and designation of a compliance or monitoring officer, we have the majority answering no. The regulation did not establish this possibility, this obligation, I mean. And here we have 2 graphics about, the first one about the possibility of defense or to justify the conduct or to request the suspension of obligations. And all the 9 jurisdictions that we analyzed provide the possibility of or defense or suspension or to extended exemption for the obligation. All of them have this possibility. And the next chart is about the third parties participation mechanisms, and all the 9 jurisdictions also provide some mechanism for third-party participation. And this only exception here, not applicable or mentioned, is again South Korea, because we do not have the full text officially disclosed. And here, yes.
Focus just on interoperability to conclude.
Yes. So here we have this big chart about the exclusionary practices in digital competition frameworks, and we have some that we understand that are three exclusionary conduct that is related to interoperability, that is discriminatory conduct, self-preference, and restrictions to interoperability, which means that are explicit mentioned in laws, these restrictions to interoperability as prohibited conduct. And about self-preference, we find that 7 out of 9 jurisdictions explicitly mention this this self-preferencing as a prohibited conduct. And regarding discriminatory conduct, it appears in 3 jurisdictions that I did not put here on this slide, but it's like 3 jurisdictions. And about restrictions to interoperability, like explicit in the law, like these terms, it's 5 out of 9. This 5. And just to finish my presentation, we also did this chart about the duty to report compliance in a number of jurisdictions, because I think this duty to report it's connected to their interoperability, because it reflects the importance of ensuring that it's necessary systematic compliance with the law. It's not simply refraining from engaging in the prohibited conduct, but the undertakings need to show that they are ongoing and systematic compliance with the law. So, and so this is our conclusion after all, because interoperability is not always addressed under a single prohibited conduct or obligation, right? It is present, sometimes explicit, sometimes through related concepts like self-preferencing or discriminatory conduct, in a growing number of regulatory frameworks. And I think this is our conclusion about this. I'm sorry to pass the time.
Thank you very much, Fernanda. It was a fantastic overview of many of the topical issues that needs to be discussed for digital market regulation. I was just rushing a little bit because we have a series of very interesting contributions, so it's important to keep on time. We have, just want to mention, we have the Slido for those who want to ask questions, so they can already populate the Slido with some questions. Yeah, so great. I think you provided an overview of important issues, and you concluded also on this important highlight that interoperability is just not a one-off measure in its systematic reporting and compliance frameworks. And I think this can be very well related to what a new type of law, a new type of ex-ante regulation can do to ensure that this framework is established. What are the capabilities, what are the institutions, what are the procedures? And we have received, the Brazilian community has received a number of recommendations from the Minister of Finance on this front. So we have here the pleasure to have with us and the honor to have with us Ravi Madruga, who is director at the Secretariat of Economic Reform of the Ministry of Finance, director for the promotion of competition there, and he can enlighten us with what's the status of this proposal and then what's its significance for promoting interoperability or anything else that he wishes to comment in this conversation. Ravi, thank you very much for joining us. You have the floor.
Thank you, Nicolo. Good morning and good afternoon, everyone. First, I'd like to express my gratitude for the invitation on behalf of the Secretariat of Economic Reforms from the Ministry of Finance. It's a pleasure to once again discuss the Ministry of Finance project for digital platforms with such a distinguished panel of experts. Before I start my speech, an important disclaimer. The views expressed in my speech do not necessarily represent the views of the Brazilian Ministry of Finance. First, I would like to quickly recap some few key points regarding the project. I promise to be brief, as I know you have all heard a lot about this project, and you are already eager for an update of the project and its current stage. So I will start with on the beginning. What motivated the Ministry of Finance to study the digital economy, the digital platforms, and basically the motivations for the project? It's always good to revisit the motivations that led the Ministry of Finance to develop this project. The timeline begins with the arrival of the new government in 2023. Specifically within the Ministry of Finance, the Secretariat of Economic Reforms was created. This new Secretariat, where I work now, has the powers that the former Secretariat of Economic Monitoring had, and also gained new powers, specifically in proposing microeconomic reforms. So throughout 2023, we had several discussions about which economic reform should be a priority for the Minister of Finance agenda. Among the various topics discussed, the new digital economy was identified as an area requiring study by the Secretariat. So, in January 2024, the Secretariat of Economic Reforms launched a public consultation to gather information and insights from various sectors of the society regarding the role of digital platforms in the economy. So the public consultation was open for 6 months, and we received contributions from 72 respondents across diverse segments of society, including public bodies, consumer protection associations, industry and commerce associations, and also we received contributions from digital platforms. In addition to the public consultation, the Secretariat of Economic Reforms hired 3 consultants who, alongside the Secretariat's staff, prepared studies based on the information received from the public consultation, economic theory, and benchmarking from 10 jurisdictions. These efforts culminated in the digital platforms report that the Ministry of Finance published in October 2024. So what happened since the report was published? Since the report was published, we started discussions inside the federal government and also with some key actors of the society. But before discussing this, talking about what we discussed, it's important to highlight some conclusions of the report to refresh the memory of those who has been who knows the report, and also from our colleagues from Europe that maybe not be aware of the recommendations that were in the report. So the main recommendations that were in the report was the creation of a digital markets unit alongside the general superintendents in our competition agent, in the Brazilian competition agent. This unit would be responsible for designating and imposing obligations on digital platforms. Both the designation and the imposition of obligations would necessarily need to be endorsed by the CADE Administrative Tribunal. For those that don't know how CADE works, CADE has basically 2 bodies. One is the General Superintendents, which investigate anti-competitive conduct and also analyzes mergers and acquisitions. And then this General Superintendent concludes the investigation and sends to the tribunal, which is formed by 7 commissioners who will decide the investigation, the administrative procedures, and also the mergers and acquisitions procedures. So basically, we are the recommendation of the Minister of Finance is to keep this format by creating a unit, a specialized unit alongside of the general superintendents, who will recommend some obligations, and the tribunal will have the last word about these recommendations. So in summary, the proposal is to amend the competition, the Brazilian competition law to create this specialized unit, establish two new procedures, designation and imposition of special obligations. Also, in the proposal, we suggest that a list of these obligations should be included in the amendment, and also the amendment of the competition law should establish quantitative and qualitative criteria for designation. So these recommendations are based on key findings of the report, such as the high degree of connection between different services, which results in the need to map complex ecosystems involving multiple business models and monetization strategies. Therefore, the report concluded that potential candidates to be designated, or these candidates are digital platforms, and may be classified as systemically relevant digital platforms in the context of Brazilian digital market. So this definition is based on the criteria that will be in the amendment of the law. And now I think what everybody is eager to hear, it's the current status of the project. I call the project because it started with a project inside the Ministry of Finance. The project resulted in the report, and now the report resulted on a bill of law. And so regarding the status of this bill of law, what I can say is that, once again, since October 2024, with the release of the digital platform report, we began discussions with ministries that are interested in the matter. Also, we started discussions with CADE, our competition agency. So since October till some weeks or 1 month ago, we resumed these discussions because the presidents of our republic joined the discussions, and really recently, in the past few weeks, the Minister of Finance, along with other ministers, agreed on a final text for this bill, and this final text was sent to the President of the Republic. So now we are just waiting the submission of the bill by the Presidents of the Presidents of the Republic to Congress. I hope I haven't disappointed anyone who expects more information. Some information regarding the bill I really cannot share at this moment, but I believe that has been a significant progress in the processing of this project within the executive branch in the last month, and as some information that we received in the ministry last week is that the submission of this bill to Congress is depending on a political strategy of the government and the relationship between the government and the Congress. That we all know that recently this relation is not being so good, but we hope that this do not interfere this project, that we think it's a really important project for the Brazilian economy, and it's a really technical bill. We don't see that it may raise political concerns. So We are really hoping that in the next days or weeks we hear more information about this bill.
Thank you very much, Javi, for this wonderful overview and update. Unfortunately, the political process is a bit unpredictable. If it was for technical merits, this bill would be already approved. I'm sure the Minister of Finance had done a fantastic job in the reports, and I'm sure he has done the same in helping to draft this bill. It was also wonderful to have this open process where everybody could participate, and you really could see how the report took into account the contributions by several stakeholders. And we think that the idea of systemically relevant players that is put forward in this bill really embarks on the right path, which is to recognize the ecosystemic effects of digital platforms. So we are very much looking forward to the imminent developments of this. I understand that now, probably because there is a period of recession in Congress, we are not going to see anything in the next coming days, but maybe at the start again, the end of July or August, there is a possibility that this bill will be introduced, so that we will be able to comment more substantively. Thank you. Then now, before moving to some Q&A, I want to give the word to Victor Jardim Barbosa, who can comment perhaps on how this bill fits, how it dialogues with the experience of CADE in digital markets, and how much perhaps we need a new regulation to stimulate open and competitive ecosystems. But really, the floor is open for you, Victor, to share with us any considerations that you think are relevant in this debate. So thank you very much. You have the floor.
Thank you, Nicolo. Can you hear me well?
Yes.
Good morning and good afternoon, everyone. It's really a pleasure to be part of this conversation. And as Javi mentioned, I would like to make it clear that the views expressed here are my own and do not necessarily reflect the position of CADE. And also apologies for my voice. I'm a bit unwell, and speaking English doesn't make it easier, but I'll do my best here. And I'll try to keep my remarks as brief as possible. Thank you, Nicolo, for the coordination and for the invitation to Commissioner Camila. And greet to my fellow panelists, Javi, Fernanda, Simonetta, Maria Luisa, Ian, Bruno, and Artur. It's a privilege to share this space with you here. And first of all, I would like to take a moment just to recognize something that remains unusual in Brazil's antitrust culture, that is the presence of civil society in an open dialogue with academics and also with members of the government, of the antitrust authority. And this is very linked to the subject that we intend to discuss here. This kind of engagement beyond the binary of lawyers and private sector and public sector as government or antitrust authority is vital for the evolution of the antitrust in Brazil as a whole. But I think the digital discussion is an important opportunity to put this new way of dialogue as a solution, as an important policy for the development of the subject in Brazil. And this is important not only for institutional reasons, but for normative reasons, for epistemic discussions. So I think we can, with these stakeholders engaged, design or regulatory practice and understand and discuss individual cases in a more proactive way. And going more directly to the subject, at CADE we have been confronted with the need to rethink some of our assumptions in digital markets. I intend to go in the next minutes into the discussion of our contribution to the call for for the public consultation of the Ministry of Finance, highlighting CAD's position about ex-ante regulation and the institutional design that CAD understood that is the right design for this initiative, and also comment to individual cases in a brief way, that is the Apple Mercado Livre and the Google News cases. Both cases are at CAD's tribunal, so I won't be able to go into details or give my opinion, but I think it's important to share some descriptions of the cases with you all. Then we can develop the discussion considering these two cases. I think the transformations that CAD is identifying in digital markets are not merely an evolution of what came before. It's a structural shift, in our opinion. And this reshape how value is created, captured, how users interact in these markets, and how firms exert control. And for the antitrust perspective, this kind of dominance is often less visible in prices or quantities or traditional ways of checking abuses or exclusionary practices, and are more embedded in architecture. So technical standards, interface design, data asymmetries, and control over ecosystems and points of access to markets. These transformations have challenged the antitrust enforcement to go beyond case-by-case enforcement. And at CAD, this meant engaging more actively in the institutional debate, asking not only how to apply the existing tools, but how our framework themselves might need to evolve to this ex-ante regulation or a more proactive action of the antitrust authority. And as I said, one concrete example that is an institutional opinion of CAD is the contribution to the Ministry of Finance public consultation. And it helps to illustrate both the opportunities and intentions involved when competition authorities engage in broader regulatory debates. So just to give more details about our contribution in this context, in early 2024, as Javi mentioned, the Ministry of Finance launched this public consultation, and I think it was the first time that CAD clearly stated that the authority supports the creation of preventive measures, asymmetric rules targeting systemically relevant platforms. CAD's position was informed by a decade of enforcement experience. So we have digital cases or case of abuse of dominance in our precedents. So we highlighted that some platform practices are not adequately captured by our current thresholds, even for merger notification, but mainly by our traditional standards of abuse. And we emphasize the need to combine ex-post enforcement with regulatory tools to address systemic risks such as switching costs, gatekeeping functions, and strategic design choices that limit contestability. We CAD also argue that Brazil's institutional design should preserve CAD's autonomy. So going to this kind of regulation of antitrust, it must protect CAD's autonomy, but also enabling multi-agency cooperation. So we are dealing with subjects as data protection, telecom, and other subjects that are related to consumer agencies. So we endorsed the creation of a legal mechanism that create channels of dialogue or articulation between these different bodies of the government, and this is part of the 12 suggestions of the Ministry of Finance that Javi mentioned before. And also, we are not, we make it clear that we are not asking for like an exactly a translation of the Digital Markets Act to Brazil, but a creation of an exempt regulation that preserves our concerns with the Brazilian challenges and concerns, and also with our juridical and institutional capabilities, and to create something that is related to our practice and to our concerns as part of this development. Now I will comment briefly these two cases, Google News and Apple Mercado Livre. I think these are cases that are being discussed in other jurisdictions, of course, with particularities. But first, I think one of the CADE's most preeminent digital cases started in 2023, if I'm not wrong, and involves Apple and how it structures the iOS ecosystems. The complaint was brought by Mercado Livre, that is a Latin American e-commerce company, that challenged a range of restrictions imposed by Apple through its developer agreements and App Store policies. This included the mandatory use of Apple's proprietary in-app payment system, so the IAP here in Brazil, IAP, prohibitions on external links or alternative paid mechanisms, and also contractual rules that blocked developers from informing users about other ways to purchase or access digital content. In response, and I will focus here in the interim measure. I think Nicolo just shared the technical note in the principal case that was issued yesterday, but we were this last day's discussion more the interim measures, and this interim measure granted a far-reaching measure that required Apple to suspend its clauses and to take positive steps to open its ecosystem. So, among other obligations, Apple was ordered to allow alternative app stores and side loading, to enable the use of third-party payment processors, and to permit developers to insert external links and calls to action within their apps. This measure will also explicitly forbade Apple from adopting technical or commercial obstacles, such as scared screens or discriminatory fees that could undermine effectiveness of these remedies. And one brief comment about Commissioner Victor Fernandez's vote that was followed by the whole, all commissioners of the tribunal followed his vote, is that although the facts of the case involve both exclusionary and potentially exploitative dimensions, the vote does not characterize the conduct as exploitative abuse. So it frames the behavior primarily through the lens of exclusionary practices and artificial barriers to market access. And the legal reason of the vote is anchored in concerns about foreclosure, multi-home and constraints, unjustified restrictions on developer autonomy. And this, I think it's an important discussion to make, that maybe this choice reflects a caution in expanding CAD's abuse categories and suggests a preference, or at least he's taking care for grounding the interim measure in well-established exclusionary doctrines under Brazilian competition law. And we have a lot of problems here in Brazil with interim measures being discussed in judicial review. So I think this might have influenced the strategy of the commissioner. And the second case that I would like to share with you is the Google News case. It's also a case that is in CADE's tribunal. The investigation started in the context of another investigation of scraping. The reporting commissioner ordered the opening of a specific case for Google News. And after the opening of the case, the Brazilian Newspaper Association in Brazil, ANJ, examined whether Google was leveraging its dominance in general search to advantage potentially diverting traffic and visibility away from non-participating outlets. The general superintendents considered several theories of harm, including discriminatory promotion, traffic foreclosure, and soft exclusion via ranking and design. And although the case was initially dismissed by the general superintendents, it was later advocated by Commissioner Camila Alves and is now under review by the tribunal, with one vote for the dismissal of the case of the reporting commissioner, Gustavo. It's important to mention, as the cases of Apple, this is also an international case, and there is an interesting production in South Africa. That is the market inquiry into digital platforms and media, which highlights extremely similar concerns. The commission in South Africa found that Google's dominance in general search allows it to act as critical gatekeeper for online news visibility, with strong incentives to favor its own monetized services and curated partnerships. The authority raises the possibility that Google's design choices may distort competition by channeling traffic and advertising revenues in non-neutral ways. Just to end this part, both cases, Apple and Google News, touch on issues that strongly resonate with enforcement debates in other jurisdictions, as I mentioned. And these are complex and still evolving matters, and out of respect of my institutional role, particularly given the possibility that they will depend on CADE's tribunal for final deliberation, I won't make further comment on their merits. And another thing that I think it's important to reflect, since we are in the context of this transatlantic discussion, these cases also invite reflection in the Brussels effect discussion. That is the influence of EU regulatory standards beyond its borders. Some observers, mainly in Apple case, found that CADE's interim decisions in Apple Mercado Livre is a sign of normative convergence with the Digital Markets Act. And it's not a one-way process. I think even in Europe, the European Commission enforcement, before the approval of the Digital Markets Act, this kind of reflection was made there. For instance, in the Google Fitbit merger, where the European Commission faced pressure to anticipate DMA-style obligations through merger remedies or ex-post enforcement. So this dynamic suggests that we are entering a new phase in digital competition policy, one which the lines between regulation and enforcement, ex-ante and ex-post, are increasingly blurred with cross-jurisdictional dialogue. And some final reflections here taken together. This case and our institutional reflections points toward a broader lesson. Digital platforms require this hybrid approach, combining reactive enforcement with proactive rulemaking. This legal design might not be enough for that. I think that even in the context of early implementation of the DMA, there are many practical discussions heavily shaped by platform lawyers, technical experts with the firms, and narrowly framed compliance debates. So maybe stakeholders' engagement is still highly uneven. Civil society, smaller competitors, independent developers, and public interest institutions are often underrepresented, even in the context of the DMA enforcement. This is why we understand that Brazil's approach must go beyond only this legal transplantation. It must include institutional arrangements that allow for broader and more sustained participation, not only of these traditional public-private interlocutors.
Perfect.
And sorry.
No, perfect. I was saying. So if you can conclude just to speed up the next part of the webinar, but I think you are reaching the conclusion, right?
Yes, only one more paragraph here. As Brazil moves forward with the legislative agenda, CADE will remain engaged in this matter, and we hope our enforcement here, our trajectory and evolving institutional practice can also enrich the transatlantic dialogue on how to govern digital ecosystems in a way that is not only fair and dynamic, but also a creation really truly democratic in this antitrust enforcement. So thank you.
Okay, thank you. Thank you very much, Victor, for this very important reflection. For us, it's very important to have this dialogue and these insights from you. This recognition of the need to collaborate with other stakeholders is very, very important. And we appreciate also your comments on the ongoing cases. They are indeed very important cases. And they are demonstrating some of the things that were commented also in the contribution that CADE made in the consultation of the Minister of Finance. So I just wanted to mention on this case of Apple Mercado Libre, the aspect that you mentioned of the extraterritorial Brussels effect was particularly visible because one of the assessments made by the commissioner in this case relating to the separability between the Apple App Store and the payment system was linked also to what was going on in the European Union. So it was saying, the European Union, you're now being forced to separate the two. So it's obvious that we have two separate products because you can do it in the European Union, so you can also do it here. So I think this kind of discussion will be repeating itself over the next few years when we have like a digital market regulation in one jurisdiction that has potentially spillover effects or equivalent situations being presented in other jurisdictions where you can find similar solutions. Now, I'm not going to, so we don't have questions from Slido, and because we have already passed our benchmark of timing, I think it would be interesting to proceed to the next segment. We will have more time at the end for Q&A, but mentioning to you that we have a link in the YouTube to a blog post that we published yesterday on this Apple Mercado Libre preliminary ruling or interim measure appeal decision, which, as Victor was pointing out, this is not the merits decision yet. The merits decision was also from yesterday, a recommendation in a technical note made by the General Superintendent for finding of infringement in this case. So the case is progressing, and I think it's very exciting to be part of this conversation as it happens, you know. So with that said, I think we are all very eager to hear from our transatlantic conversant, so our partners in Europe that have a lot of experience to share. So I will then indeed move to that segment, giving the word initially to Professor Simonetta Vessoso, who, besides working all around the clock on digital competition. She participated in one of the first workshops organized by DG Competition, DG Connect, on interoperability at the very start of the DMA discussions, and she's following the latest developments in Europe with regard to interoperability. So I'm really looking forward, Professor Simonetta, to hear from you. Thank you very much for joining us. You have the floor.
So thank you so much, Professor Zingale and Niccolo, for this great opportunity to participate in this transatlantic dialogue, which I think it's very, very, very timely. We need a sharp conversation drawn from reflection, experience, and aimed at what truly matters. And also, I congratulate and I commend the Brazilian government for all the efforts. I'm looking really forward to reading the bill of law when it will be made available. We have been following, actually, as a researcher, I've been following, I hope, pretty closely what was happening in Brazil. I found it exciting. And also, thank you so much, Fernanda, for your overview of the different legislation. I would have had some comments on that. Perhaps we can go back to the Q&A to some things that you raised, which I found particularly interesting. Well, okay, so our topic today is interoperability. Interoperability, Niccolo quite correctly reminded me of the fact that I was in the first compliance workshop. Well, at the time, it was not even called like that. It was like introductory workshop. And it was about Article 7. What I will be discussing a little bit later is Article 6, but Article 7, of course, was an important fight, I would say, also from the side of civil society, which was mentioned many times already, because it was something which was not part of the original draft by the Commission. So also because of the pressures by civil society and by the Parliament, of course, we were able to amend the draft proposal in order to include Article 7. So that's what I think it should be mentioned. Civil society is extremely important in the drafting, something that I understand in Brazil has already happened, but also later in the enforcement. And this is something that I think, especially now in this compliance phase, the digital markets could have done better. So if Brazil can do better on that side, please show us the way, because I don't think that the DMA has foreseen so many rights for third parties. And of course, there is always the possibility to engage with the Commission, but it's not really structured and formal. Okay, but let me be clear, until recently, there wasn't much of real substance to say about interoperability in digital platforms and its regulation in the EU, because there was nothing really particularly useful, I must say. But in the last few months, luckily, something has really shifted. So interoperability in digital platforms is starting to feel a little bit more real. And there are 4 developments I will try to briefly mention to you, 4 points which I think can hope at least meaningfully contribute to this transatlantic dialogue. So first of all, near-field communication on Apple Pay. Well, until mid-2024, Apple reserved access to near-field communication on iOS for its own payment service, Apple Pay. Basically, what did it mean? That Apple Pay was the only option on iPhone for tap-and-go payments in store. So it's NFC is a standard technology not invented by Apple. Virtually every payment terminal in Europe is NFC enabled. The European Commission stepped in June 2020 by opening a formal antitrust investigation. It closed it almost exactly 1 year ago. So it was on the 11, can't remember, in any case, July 2024, and accepted commitments from Apple. So based on the commitments, Tap and Go on iPhone is now available to rival payment apps, which can enter the market and compete with Apple Pay. Okay, this is great. This is basically, I would say, the first real breakthrough for interoperability in digital platforms in the EU. 1 year later, we should ask, okay, has anything really changed? Because this possibility is already there, has been read there for 1 year. Well, the answer is unlikely, not very much. So there have been a few entries. So for instance, Vipps mobile pay in Norway, PayPal in Germany quite recently, Some German cooperative banks are getting ready, but we are really very far still from a truly European level impact. This is sadly a reality that echoes what both the Letton and Draghi reports have been saying, so to prominent advisors to the Commission. So in several key sectors, we remain a long way from a European single market that would allow innovative entrepreneurs to scale quickly and effectively. Okay, so I think it's really also to blame on that effect that we don't have any pan-European solution yet. And then this brings me to the second point. So can interoperability help promote not just competition, but also digital sovereignty, which is a very hot topic in Europe at the moment? Well, interoperability is at least part of it. It could be a part of the stack, like NFC on iOS now, and it's of course good. But I think a more effective strategy would have been to go the way Brazil went, basically. So in Brazil, so we had, from the very beginning, we had taken, they built, so with your PIX, you build the digital, public digital payment infrastructure in Brazil. And on top of that, you could have quite a lot of innovation. The European system didn't go that way. So now those apps struggle, okay, because they cannot rely on Visa and MasterCard only if you want really to create something European. So I think in that respect, I think Europe has to really learn quite a lot from Brazil with what Brazil did. And I think Professor Belli in Brussels in September really posed this question. How come you don't have anything similar to the PIX yet in Europe? Well, we tried. We have the single euro payments area. High ambitions didn't work very well. Well, there is a fix here, instant payments regulation, which is now starting to bite, perhaps. But it was not brave enough. Okay, so the banks had many workarounds possible. So there was not a clear mandate, like in Brazil, to adopt this new infrastructure. And I think we can really learn from Brazil a lot in that respect. Okay, second point, Android Auto or Auto in Article 102. This is again something positive, good news. The ruling by the European Court of Justice of last February, so the highest level. So what happened there? Google refused to allow Enel, X, it's an energy provider, but also into energy for electrical vehicles. So there was an app, a charging app, and this charging app, Enel wanted it to interoperate with Android Auto. Google didn't want it, so cited many security concerns, even the cost of developing new templates. Then, I mean, a little bit laughable, of course. So the Italian Competition Authority disagreed and sanctioned it as a refusal, Article 102. Okay, so then came a preliminary reference to the EU Court of Justice. The court responded, not with a revolution, but with a useful and timely clarification of the so-called essential facility doctrine. Well, it's perhaps limited, but it's a step forward. And important from my perspective is the court reasoning that sort of was able to dismantle the familiar incentives preservation defense, invariably deployed by big tech in abuse of dominance cases. Okay, what about incentives? What about innovation? Okay, the court made clear that unlike the infrastructure, for instance, in Bronner, Google had not developed the Android Auto operating system to serve its own needs to secure a competitive advantage. Okay. On the contrary, it was explicitly designed to encourage participation by complementers, a fact that clearly undermines the argument that granting access would have reduced Google's incentives to invest. Okay. Other good news from Europe, also a very recent one. So that would make easier, I would say, from the point of view of Article 102, so abuse of dominant cases, to see a refusal to provide interoperability as an abuse of dominant position. So clarified some aspect of the Bronner criteria. Of course, there are many things which are not covered. Niccolo, you mentioned the idea of ecosystems. This is very much based on the idea of ecosystem. But what about, for instance, cloud? Okay, something we are going to discuss later as well. So perhaps it's not the end of the day, but it helps already. Okay, so my third point would be DMA and Apple again, which has been already mentioned quite a lot. So let's now return to the trenches, to the DMA trenches, basically. So Article 6 6.7 in particular, which is the obligation for designated gatekeepers to enable interoperability with their operating system, hardware, and software features. So Apple was supposed to fully comply with these and other obligations by the 7th of March 2024. It didn't, but the Commission took notice. So with regard to articles, so we already have another decision, so an infringement decision against Apple concerning steering obligation, which has already been mentioned here. And with regard to Article 7, the Commission gave a different answer, which I think was quite interesting. And I think it really should be looked at carefully from your perspective in Brazil as well. And I hope the bill includes it. It didn't issue a non-compliance decision, but a specification decision. Okay, I think this is actually one of the best parts of the DMA. So the idea is, okay, we give you time, come up with the solution. You have to show us that when we have enough evidence, and the Commission had enough evidence that it was not going in the good direction, so the Commission can step in and say, okay, to comply with this obligation, you have to do this, and this. And of course, the Commission was able to do that also because the Commission was able to look eye to eye with Apple because it has already acquired quite a lot of technological know-how. Okay, so you have to discuss with Apple how they should provide interoperability. Of course, you have to know quite a lot. You need to know quite a lot. And I think, again, there even civil society provided some very important inputs. So the dialogue is very, very important with civil society. Civil society, of course, they know their stuff. And I think this is actually going pretty well. So it's, of course, Apple is not happy with it. It will definitely appeal against the decision. But I think the decision is actually, from my perspective, even better than what the Court of Justice has been providing us with. Okay, and among the features that are going to be, which the Commission specified, is also NFC again. So features, one of the features, NFC controller in reader and writer mode. So you find quite a lot of technical stuff there, which goes well beyond, if you want, the commitment decisions, because it's much broader. And another very important principle in the decision, which I would like to highlight here, is the fact that the Commission really said it's not for Apple to decide which are the products and services which will emerge from this interoperability. Okay, so it's going to be the market which is going to decide. It's going to be innovation which is going to decide. So because that was a very dangerous interpretation that would have, of course, hampered the whole system. So the last point, very last point, do we have still a couple of minutes, Nicola? One, okay, okay, 2 minutes. So the last point, it has to do with a sense of urgency. Okay, so now we have seen improvements in different forms, shapes, colors, but still, we feel urgency in Europe. Perhaps you feel urgency in Brazil, perhaps a little bit less. You don't have war on your continent. We have it. So we feel, and I think still, even though I see movement, I think in Europe we're still moving too slowly. So don't copy us too much, okay? So we are not always best of class. So the reform of competition policy is underway, but what we have seen so far, I would say, is rather underwhelming. At this stage, if we already realize that the DMA is not enough, okay? At this point, we already come to the conclusion it's not enough. While it is limited, perhaps it is limited in scope, we need more core platform services, we need more obligations. The time to act is now, okay? We shouldn't waste time. And then, of course, no, we cannot expect big tech and not even largely native industries such as banking to deliver effective interoperability on their own. Not at all. Okay, again, I'm a fan of this specification decision. So how do we move forward? First of all, perhaps we need looking back. So we need a proper retrospective analysis. How did we end up depending on private infrastructure for so much of our digital lives? Okay, of course, you cannot just blame antitrust for that. I think it's much broader, and that should be clear. So their story is more complex. I quite like what Robin Bergeon said recently, that basically said, well, things moved so fast in digital. We didn't even recognize that we were dealing with digital infrastructure. So in normal life, we had roads, trains, etc., etc. Here, suddenly, we had all of them. And it was very, very difficult for society to cope with that. So what do we need? Well, first of all, at the very least, we need to know which digital infrastructure matter for society and the economy, and how to regulate them, perhaps even create them, as Brazil has done with PICs. And of course, interoperability plays a very important role in both. Then, of course, competition law has an important role to play, as we are seeing here in Brazil, to prevent further digital platforms entrenchment and power grab through anti-competitive means. Refusal or to interoperate can be one of those. In Europe, the legislator has been giving a strong mandate to the Commission to regulate big tech. Brazil, we have also seen heard today, is thinking along similar lines, but also regional lines, like foreseeing for more civil society participation would be great. So Brazil has also shown us that it can resist pressure by big tech and is willing to do so, which is great. I think we could really learn a lot in Europe, also in that respect. And also Brazil has shown us that it's able to build good public digital infrastructure. We can learn a lot also from there. So given all that, I think the ground is set for a dialogue that cannot but be very rich and full of promise. But let's be clear, these are not only technocratic debates. They are democratic ones in many ways. And as Alessandra Ghiz, a member of the European Parliament, recently said, if we give in on digital, we'll lose everything. Thank you.
Thank you, Simonetta. This was fantastic. Also, thank you for appreciating the role of Brazil played in this global discussion, particularly on the topic of digital public infrastructure. I think, yes, as you mentioned, Brazil is a leader. And I think this connects well to what you said on the Android NL Auto case, which was about opening an ecosystem. As you mentioned, in this case, the idea was that since the product had been developed to be open to third parties, then it basically should be ready to give interoperability to any third party, except when this compromises security or privacy in the ecosystem. And here it was forcing to basically develop a template if that template was not available to permit this interoperability. So in case that we have a digital public infrastructure that already dictates, what should be the protocol, this facilitates in a way the interoperability discussion. In fact, in the Apple Mercado Libre case, the commissioner said that Apple should make it possible to make the payments through the PICs, the digital public infrastructure for payments that we have developed here. So I think this is a very important discussion, and I wonder how it connects to another layer of interoperability that would very much benefit from a common protocol, which is the social media layer. And I don't want to put words in your mouth, Maria Luisa, but I think this is a very important discussion. I hope you can mention something on that because I know you've done important work on it. So I give you the floor now. Thank you very much.
Thank you, Niccolo. Thank you very much. I'll try to share my screen and use a couple of slides that I've prepared for the purpose, but do not worry because I'll be very, very brief. And especially my aim for now, if I manage, is just to tell you a little bit of a story of the side of this conversation that I know more, because all the rest of details have been already identified or will be identified by the one after me. So no need for that. I hope you can see well. Nope. Sorry. Is that okay? Yeah. Okay. So this is, sorry, you don't need to say this one, and I don't need to see you for the moment. My focus, as Nicola said, is interoperability in the environment of social media. And I took the liberty of calling it a decades-long love story, not because I think that there is much love implied, but because it's a struggle. And so I tend to identify it with a decade-long love story. Only a few years ago, this was more or less a scenario. We had very few social media platforms that looked very beautiful with a lot of different variety, but it was just a very closed system, and all the rest was a desert. I have put down a few of the elements that characterized the status quo back then. The main one are concentration, gatekeeping, and bundle for what concerns and what I think is relevant for the purpose. Because social media came into the market as a big package, as a bundle of a number of services. But in fact, we have many services. We have hosting, we have messaging, we have content moderation, we have content curation, and many more. But it was created as a bundle, and so it remained for a long, long time. And some would argue that it's still the case. All these elements were already spotted by a number of expert reports and regulators, and some governments were discussing about this. And we're talking about late 2019, 2020, maybe early 2020s in some countries. But this was more or less a status quo. Who was talking about it? Some civil society organizations. Article 19 was one of those. I think the first time I went to a human rights gathering talking about unbundling, it was a challenge, but now, fortunately, the situation has changed quite a lot. There were some alternative players that were talking about it because they were struggling. They were trying to enter the market with services like You Choose, a plugin that you could add on YouTube and define your feed, or do not forget that Mastodon was there since at least 2018, I think, although, you know, the number of users was obviously much lower than it is today. Very few regulators and governments were still talking about it. I would argue that they were talking about interoperability, but not necessarily interoperability in social media. And they were sometimes focusing, definitely, even if they were talking about social media and interoperability, the key focus was not recommended systems, was still content moderation, which is a different story for this conversation. So this was the beginning, and it was only 5 years ago, I would argue, even less. What were the main pushback where we tried to discuss interoperability in the social media environment? The traditional ones, in a sense. Privacy concerns, because interoperability means, I'm oversimplifying, of course, but more players having access to data, a huge amount of data, including personal data, of course. Security. Other kind of pushback that I received talking, especially with regulators, but also with market players, were about market saturation, the fact that people really want to be on the same platform, so there might not be space for more than 2 or 3 platforms in the entire market or ecosystem, and therefore the lack of users' demands. And then what kind of incentives? Because the main problem was the bundling and the business model behind the bundling. So what kind of alternative business model could have been sustainable in the environment? And obviously, there were problems with the content moderation and the sort of integrity of discourse in social media. We all know how it ended. So anyway, those were the main pushbacks. What is the situation now? It's improved. It's not a desert no more. But we do have a few more actors. I would argue that they're basically limited on the vertical interoperability. So we do have a couple of more platforms like Thread and Blue Sky, but the reality is that where we have a little bit more variety is in the possibility to sort of combine and have a little bit more agency as users. Mastodon is offering the possibility to shape your own feed. There are a number of other interfaces that allow us to sort of check all in one page our messaging apps, or to decide which kind of build our own, magazine online. Some of them are still work in progress. Some are much more advanced application, but it's mostly what I would define largely vertical interoperability. The other main point is who is talking about it. Again, the players that we saw before, but I would say that dominant players have started to talk about it, and they rejected even just the sound of it until a couple of years ago. And why so? Why they're starting to talk about it? Because we're starting to see interoperability obligations in a number of regulatory frameworks. So regulators are engaging a little bit more with this kind of conversation, not necessarily. Not yet with social media environment, but much more in any case. Governments the same, and then courts, as Simonetta has shown us. Main pushback, I would say that the main pushback right now is not necessarily privacy, security, or the incentives, but it's very much about the governance model. So if we have more platforms, or we have more social media, or if we have interoperability at vertical or horizontal level, how can we make sure, for example, that the interaction between Thread and Mastodon, it doesn't undermine the governance elements of Mastodon that make Mastodon a true alternative to Thread? So what about, for example, decentralized policies for content moderation? Same, we can argue similar discourses, for example, when we have interoperability between WhatsApp and Signal. They have different policy when it comes to privacy, so how can we sort of make sure that those alternatives remain the same? There are ways, but this is one of the main pushbacks, I would say. My last slide, getting to the conclusion, is this is where we should aim at. Rainforest, the maximum variety possible. And we're definitely far away from that. Is it the DMA, the DMCC, or the new Brazilian rules going to be enough? Probably yes, probably not. I would say that this is the goal. Multiple actors, vertical and horizontal interoperability, plugs in protocols, and I link to what Nicola was saying before. Possibly a variety of protocols. We don't need to bet on a single one, not yet. Maybe we can test and see. All the players that we have mentioned before are essential to make this reality happen. I agree with Simonetta, without regulatory mandatory obligations, there are no incentives for the players to do it by themselves, dominant players. I would argue, let's not forget the people. Let's not forget that demand and supply, the dynamics can be changed if we educate in a way, or re-educate people to be active players in this scenario. The main advantages that I would argue as a free speech organization representative is not only open and innovative markets, but also dispersed information and opinion power, which is a challenge for the infrastructure we have today, and choice for people. I conclude simply by saying, if we had time, it would be good to talk about the elephant in the room, which is we might get in 2 years' time or 3 years' time to the perfect rainforest of social media. But is this going to be enough? Is recommended systems what is going to be the key bottleneck and the key access point for content circulation and access to information in 2 or 3 years' time from now? Because we're seeing already this booming of intelligent agents, conversational interfaces, personal assistants, and so on. So probably we're late, and if we get there, it's going to be already too late. I hate to conclude on a negative note, but the positive side of this is that the sooner we acknowledge it, the sooner we can act upon it.
Oh, fantastic. It's good to end on a realistic note, not just have blue skies at the horizon, because indeed it's a challenge. It requires continuous engagement. But I think it's important what you mentioned, like the plurality, the ability to choose, and it connects to a point about digital public infrastructure. So PICs or any other government produced infrastructure might not be the only solution. There can be, when you do a public infrastructure, you are also steering the consumers towards one solution, but you are preventing the emergence of others. So I think we should look in a dynamic way, because the public infrastructure can also become outdated over time, as you say, in the context of AI agents. We might need to build another one. So we need to keep looking and have an evolving conception of interoperability. I think there's a nice discussion tomorrow, if I'm not mistaken, organized by SER on agentic AI interoperability as part of a key tenet of this discussion. So let's keep looking. And digital public infrastructure should not be in a sense of public because it's developed by the government, but public because it serves a public purpose. It's governed in a way that serves the public interest. But with that said, I think we can relate this to some of the discussions that are occurring now on the implementation of the DMA and of the DMCC act in the UK, which our colleague Ian has been very active part of, and increasingly will be part of this discussion also in the next month. So I'm very eager to hear from him how he can relate to these experiences and show us a new path forward for Brazil based on what has been happening on the other side of the Atlantic. So Ian, thank you very much. You have the word.
Muito obrigado, Nico. Lo siento, no puedo hablar português. I'm sorry, so I will speak English, but I hope you can use live translation tools if that helps on the video recording. And sorry, tell me if I speak too fast, because I know native speakers often gabble along, and I'm going to try very hard to stick to your deadline. I even have my timer ready, so I'm starting that now. So I've got 9 points, very briefly, each point less than 1 minute. So urgency, the EU, these debates are not new, as everyone on this call knows. They go back to, they go back at least 10 years. The UK took a bit of a lead internationally with its what's called the Furman Review. It was chaired by the chairman of then President Obama's Council of Economic Advisors, Professor Jason Furman. Strongly recommended interoperability. We still don't have it. It's taken a very, very long time to get the Digital Markets Competition and Consumers Act into law, and an even longer time for the CMA to take the decisions under it, which it's empowered to do. So this is a warning for Brazil and for CADE. Passing the law is just the first step. Australia is explicitly passing a law which allows the Australian Competition and Consumer Regulator to make use of, to learn from decisions by other competition regulators around the world when it comes to things like designation of systemically important firms. I always forget what the acronyms stand for now. SMS firms in UK terms, gatekeeper firms in DMA terms. Brazil's actions over the years on the Marco Civil and its Supreme Court actions against X/Twitter have been impressive. So I hope Brazil can sort of roar ahead of Europe and the UK in what it's doing. Simonetta mentioned the EU's compliance workshops. There's been one today with Google. There was one yesterday with Apple. I can only urge everyone watching to ask the European Commission for access to the full video and the Slido questions asked, because those were very, very illuminating events. And even jurisdictions with the size and resources of the EU are not going to win this fight if they do it alone. They need to work together. So this is my second point, the importance of cooperation between not just competition regulators, which they're generally very good at doing through the International Competition Network, through the OECD, having the OECD doing a lot of very detailed analysis, which it has done on interoperability. It's done good stuff. There have been a whole wealth of reports and reviews published by the democracies. I think we can move on. We have all the evidence we need now. We need action. And indeed, actually, I think the UK has left things so long that there's a real risk that the DMCCA regime is going to fall apart, because the big tech firms have managed to convince the no longer new Labour government, supposedly left-wing government, that the only way to get the growth and foreign investment in the UK economy that the Labour government understandably wants is to basically ease off competition enforcement. I would argue strongly against that myself, but that's for British politicians and policymakers to decide. Third point, as you've heard and will continue to hear, I'm a computer scientist, not a lawyer or economist, to be clear, although I spend a lot of time talking to lawyers and economists. Interoperability as a technical matter is highly complex, highly complex. And this is a legitimate criticism of it, because very few people have the computer science and law and economics background. You know, I hope it doesn't sound arrogant. There aren't that many of me in the world that have this sort of combination of expertises, and without a good understanding of all of them, you're always going to struggle. As you know, competition authorities are used to information asymmetries against the enormous firms that they are created to regulate. One way of addressing that is through structural remedies. As you all know, the history, you know, going back over a century of competition law in the United States, in Germany, then in the EU and elsewhere. One approach is, say, breakups. We cannot allow firms to get so large that democracies cannot control them. And that remains the ultimate sanction in the DMA for repeated systemic flouting of the DMA. And, you know, that may well be needed ultimately, given the way that Apple in particular has pushed back so hard, as Simonetta noted against the Commission, the Commission's attempts to enforce the DMA. Point 4. One thing for Brazil to learn very much from the DMA experience is that the gatekeepers so far have successfully in that they're doing it. Doesn't mean it's necessarily legally compliant, but the Commission has not launched any investigations into this yet, let alone enforced against it. The gatekeepers have argued that the roughly 20 obligations that designated core platform services under the DMA must follow in Articles 5, 6, and 7 should only apply for the benefit of EU residents and EU businesses. This is something that's very damaging, actually, for the investment that is needed by competitors, by startups, by tiny firms, not by the world's 7 largest firms that have been designated by gatekeepers. And this is such a problem that there is not yet a single implementation of Article 7 messaging interoperability under the DMA. We know very well why, because we taught Simonetta and Isa and others, including me, talk to the startups that want to implement it. They cannot afford to. The investment is too high, given the relatively limited customer base that today, under this interpretation of the DMA, which I'm far from sure is legally correct, but I'm not a lawyer, certainly not an international lawyer, until the Commission does something about that, and or the EU, Brazil, other jurisdictions cooperate closely to make sure to get over this problem, that's going to remain an issue. Article 7's very deep, if you compare Articles 5, 6, and 7 of the DMA, 5 and 6 contain roughly 19 very high-level obligations, like prohibitions on self-preferencing. Article 7 goes into pages of detail about precisely what gatekeeper NICs, as EU law calls them, number-independent interpersonal communication services. What a mouthful. It basically means messaging, email, actually. It does cover email, although no email services have yet been designated, despite clearly meeting the quantitative thresholds, I would argue, under the DMA. The advantage of this very detailed set out is that very important issues like the impact on privacy and security, on end-to-end encryption in these services are very, very clearly covered by Article 7. The disadvantage, of course, is over time as those services evolve, Article 7 will become less and less relevant to the evolved services. Of course, we see these services evolving all the time. This is one argument against detailed interoperability mandates, actually. And Simonetta mentioned the way that the Article 6.7 technical specification had been done by the European Commission. I assessed that independently in a report commissioned by Meta, which FGV has published as a discussion paper, and I'll put links to all these resources and my notes in the chat when I'm finished. Apple's claims about privacy and security I was Professor of Information Security and Privacy at Oxford University. I have a PhD in it. I assessed them in detail. I spent a month looking at them. Apple's claims were false in my assessment. I am a strong advocate for human rights, particularly privacy and data protection. I've been advising governments, including the United States government, including the United Nations, many other governments over the years on information security. I'm all for strong information security. Apple's claims were false. And I hope Apple will stop repeating them because it's not helping this debate globally. Apple has some legitimate points about how the Commission has implemented and enforced the DMA. That is not one of them. But of course, this goes back to a much broader ongoing debate. You know, the reason we did not have ex-ante regulation until very recently, the reason that CAGE, amongst others, said the antitrust existing powers are quite flexible enough to deal with digital markets. CAGE has changed its position on that, as we heard earlier. I understand why. I think they're probably right in the current context, but it's an eternal conflict between detailed ex-ante rules and more flexible ex-post enforcement that has enormous problems when the world's largest firms string out court cases for a decade plus. Like if you look at the Intel case in the European courts, for example, we all know all of the problems with that. The gatekeepers are trying to do the same thing with the ex-ante regulation. So Apple yesterday and Google today tried to talk out the regulatory dialogue, just endless, irrelevant information. The Commission should not have allowed them to. As I said loudly in the Slido Q&A online yesterday, we'll see if the Commission learns from this experience. Point 8. Blah, blah, blah. No, I've covered point 8, so point 9, finally, sticking to time, Nico. And building on what Simonetta said about Android Auto, I think that raises a really fascinating point, a much broader economic business model point. You're all probably familiar about what seems the relentless rise of the platformization of everything. You know, as you know, it's not just the core platform services that the DMA specifically covers. It's not just, you know, transport through Uber, accommodation through Airbnb. Brazil has all of its own, of course, because Brazil's a large enough market that so far they haven't been eaten up. That's a more traditional M&A issue, of course. And I wonder if the point that Simonetta made, which I thought was very insightful, that the Court of Justice has said, look, a platform that is built to attract complementers and then effectively and customers inside markets, and then effectively extract ruthlessly out of the economic and data flows across that platform. The refusal to supply interoperability is an abuse of dominance. I think that's an incredibly powerful point that Simonetta discussed from the Court of Justice's decision. And I wonder if this is finally something strong enough to actually reverse this trend of platformization, which I have to say, given how platform monopolies have behaved in practice, I think could be a good thing. Thank you.
Thank you, Ian. Fantastic dive into some of the most controversial issues. I think, well, the aspect of investment in interoperability by those that want to receive it is something that is often overlooked in these discussions. So I particularly appreciate this point. And also the other point that you mentioned of the interface between the ex-ante and ex-post, which I think would be a tremendous question for also all of us to discuss, what's the proper balance, what's the proper mechanism to make these two dialogue. Because in the Android case, well, basically this has broader application than the designated platforms in the DMA, and it's a very powerful complementary tool. And I think we would benefit from something like that also in the Brazilian context, not limited to essential infrastructure that was the previous application of the refusal to deal case law in Europe. But now you mentioned, I want to touch on another point you mentioned, which is, you mentioned that the services that are designated under the DMA, you touched upon, the need for designation, and cloud services we discussed so far that has not been designated but it's potentially a very important market. Another one that has not been designated in the DMA is the virtual assistant. And these two are very important future areas of work for competition authorities. So since we don't have Slido questions, I would move immediately then to the next segment and keep the discussion part for the end, but I already anticipate that this interaction of ex ante and ex post could be something relevant for us to reflect upon. And so I want to then pass the floor to our colleague from INSPER and CAGE, our friend, also a collaborator with us, Bruno Renzetti, who is looking closely at these cloud markets and can tell us more about it. Thank you very much, Bruno. You have the floor.
Thank you, Nico, and always glad to contribute to your initiatives and glad to be with everyone here as well. I'll just share my screen quickly here. I promise very few slides. I hope you're seeing the slides. Is that okay?
Yes.
Okay, good. Let me do the now better. Okay, so as Nico mentioned, I want to touch upon some points on cloud computing and maybe competition concerns on the sector, as well as regulation concerns, and what we can think for the future, how to deal with issues that are arising in the sector and how to deal with them in the future. Just a quick disclaimer, as Vitor did, all views here are personal and do not reflect any views of the Brazilian Competition Authority. Okay, so the relevance of the cloud. So why is the topic important? Just a few pieces of evidence here. In the last meeting of the Competition Committee of the OECD, there was a dedicated panel on competition, the provision of cloud computing services. Here's the cover of the background note produced by the OECD. I highly recommended those interested in reading, because there's a very nice overview of what has been happening in the world lately, and also the contribution of some of the countries. Particularly the Netherlands and France have produced reports on the topic, which were pioneers in the field, and to give us a broader understanding of the competitive landscape of the cloud, of the market for providing cloud computing services. So what are we talking about when we talk about cloud computing services, or CCS? Mainly, we can divide the sector into three subsectors or services. We have infrastructure as a service, platform as a service, and software as a service. And here, this figure I took from the report by the OECD, you can see how they mix the customers' own applications or those provided by the cloud. Usually, the cloud infrastructure is always present, but not necessarily the platform as a services or the infrastructure as a service. And this debate is interesting, because then we're talking about the control that either the supplier or the customer have over the service. So infrastructure as a service, the supplier controls the infrastructure, whereas the customer controls the remainder. And on the other end of the spectrum, we have the software as a service, in which the supplier controls everything from infrastructure, platform, and the software. And here on the left-hand side, we have a description of each of the subsectors, and we have competitive concerns in all of these three segments. But it seems that infrastructure as a service is the real area in which we have a more concentrated market, and then we should be taking a further look at it. So, how is the market looking for cloud computing services? These graphs I took from the report by the Dutch Competition Authority. So we practically have a duopoly in between Microsoft Azure and Amazon AWS. Each of them with almost 40% of market share, either in Europe or here in the Netherlands as well. And more recently, in the OECD report, we have data from different countries, and it's very clear that Amazon and Microsoft have the largest amount of market share, be it in France, in the Netherlands, or in the UK, as well as Korea and Japan. And Google Cloud here shows up as a distant third player in the market. But according to the reports, Google has even though it has a smaller market share, the fact that it offers a wide array of services makes it makes it able to exert competitive pressure in some sense or another towards Amazon or Microsoft. But this is the landscape we have right now in different countries, practically a duopoly between Amazon and Microsoft in providing cloud computing services. And if you look at the financial numbers of those companies, also we can see the relevance of the cloud services. So this table I took from the most recent take-in form filed by Amazon to the SEC in the United States. And here we can see the relevance of the AWS segment for Amazon financial report. Even though it was not the largest in net sales, we can see that it had if you compare to the other two, had this great operating income, and also by far the least operating expenses to Amazon's. So this might tell us that it doesn't take that much investment. It is not that expensive to expand into the cloud service for Amazon, and it responds to it accounts for approximately 60% of the total operating income of Amazon. So only we think of Amazon as the retailer, and actually in net sales, the retailing activity has a larger amount of net sales. But for when we figure out the operating income, the cloud computing services supplied by Amazon actually have the largest share in the operating income. So it's Amazon is much more a cloud company than anything else nowadays. So what are the possible competition concerns for when we talk about cloud computing services? I'll just focus on one specific here, given our time, which is the locking effects. And that has been very much explained and explored by the report by the ACM, the Dutch Competition Authority. Because it seems that competition in cloud computer services is a competition for the market and not in the market. Okay, so the first mover, when a company or a person adheres to a cloud computer services, they very rarely change their cloud provider, given many difficulties in changing the provider, be it technical barriers or even the costs of removing data from the cloud. What happens from that? We can see that there's some sort of path dependence by the user. So they keep using the cloud service, giving the hard time they have in migrating to a different service. So a unsatisfied or unhappy customer will most likely not migrate to a different provider. Also, providers know that their consumers rely upon their services and depend on the services, so they have larger bargaining power towards the customers, and incentives to charge higher prices, impose unilateral contractual terms, and so on. And also, very typical effect, consequence of locking effect is reducing the possibility of entrants and small providers to compete with larger and well-established providers, because those entrants know the current customers will probably not migrate to a different provider given those difficulties in the cloud service segment. And okay, so if you look ahead, and then here I think I'll touch upon some of the points brought by Simonetta already. Interoperability in cloud computing services. There has not been a designation of gatekeepers for the CCS, even though it has been listed as a core platform service. There has been some discussion whether they would reach the quantitative thresholds. One solution we could think about is qualitative designation under Article 3.8, and that would not be the first time the Commission did it, because that happened in the iPad OS decision. Then, if cloud providers were designated gatekeepers, then we could start discussing remedies and obligations, interoperability obligations, for instance. And here are some excerpts from the iPad OS decision, and then it makes clear that users are less likely to switch between ecosystems, as well as that cloud storage services play a significant role in the ecosystem. Also, we can think about the interplay with the Data Act in the EU and the differences between portability and interoperability for purposes of the Data Act. And in the Brazilian context, we touch upon the topic of digital public infrastructure. The federal government, I believe last year, started developing they call the government cloud in partnership with private companies. And those cloud solutions would be aimed to government of states, cities, and the federal government as well. In this discussion, and that's initiatives that relates to the discussion of digital sovereignty, that has been a topic here as well, and also safety of sensitive information that follows through government systems, and to not rely on private infrastructure for such important data. Hopefully I was able to do it in time, and glad to discuss.
Thank you very much. So much interesting stuff. Well, I think it relates very well to the discussion that we were having, as you pointed out, with Simonetta's mention of digital public infrastructure, but also it brings some specificity of a lock-in of cloud that are not maybe so predominant in other services. And one solution could be also standardization. I don't know, that could be an alternative to interoperability, to have some templates and ability for users to use similar functionalities across different platforms. But I just want to throw it out there before we move to maybe a final round of reflections and questions and answers. I want to pass the word to Artur, last but not least, that will mention some of the work that we have been doing, what we've been thinking about this topic of ex-ante regulation more generally, and how it fits into this discussion. Artur, thank you very much for bearing with us all this time, and you have the floor.
Thanks, Nicole. I believe it is always tricky to do the final contribution in a diverse panel, but I try to sum up something that I've been thinking while listening to you guys. Well, I believe that maybe the contributions today, especially the data, the different jurisdictions and different sectors where we are discussing interoperability, can be summed up in a broader approach towards interoperability. I believe that maybe this can help to sum up some interesting issues that permeate the varying instances on the issue. The first of them is like the diverse set of practices and misconducts that can be mobilized as antitrust infractions or ex-ante regulation infractions. This can be both technical or non-technical. Second off, it can also help to get more of a sense looking at the history of antitrust and interoperability issues. We can, while approaching a broader issue, a broader stance on the issue, can go further from Microsoft case or even to railroad cases. This can be made up a sense in the history of antitrust and how to deal with that. Maybe finding the core principles that reunite both regulation and antitrust approach. Third, this also points towards both market and non-market dimension on interoperability. While we are talking about interoperability as a form of enabling market participants to go on ecosystem and to develop their business models within certain kinds of platforms or key players, we can also talk about this topic as a form of self-determination within these spaces. And this is particularly important as we start to frame these players more as broader moral spaces of market and non-market participation. And this can go for social media, but this can go also for settling arrangements or settling spaces within marketplaces. So this is both a issue of market development and non-market participation. And well, we are advancing some of these ideas in our white paper on Brazilian regulation, and maybe three spaces where a broader instance of interoperability can play a role are the flexibility of approaches. So we do not have to go for all or nothing intervention. We can go for a sunset clause, we can try, we can experiment. And when we have this kind of broader space of harm, we can also have a broader space of antitrust or regulatory intervention. Second, we can go for a more cooperative way of regulating. So it's very hard and tricky to assume that any regulatory body has some kind of inefficiency regarding business models, especially digital ones. To look at digital players is to look at a black box that we usually do not know how it works. We can rely more on comparative ways of shaping regulation and innovation based on business models and cooperation from regulated players. This is not to say that we are going to be more, I would say, even less interventive, but it's actually to try to develop better mechanisms to go for compliance and actual compliance. And third of the comments that we can go for is like, how can greater participation in the regulatory space can enhance interoperability measures? This is particularly true based on the same black box problem. Maybe the affected party player or business user is the best source of information that we can get while regulating ecosystems. And we should rely more on participation and be more open to listen to these voices as we are dealing with some problems that we are sometimes do not know their extension. So if a technical interoperability issue is more clear, maybe because it's less based on a qualitative review of the claim. The other case of contractual or even political or discriminatory interoperability issues should rely more on information brought by third parties. And this can be an approach to actually to frame this model of ex-ante regulation. And finally, to deal with that as a more broader issue on competition policy and not only a market one, is actually to try to get some kind of consensus here. This is not to say that, okay, we are going to regulate because we have to regulate, but actually to find, fair and other greater principles that maybe be better to govern these spaces and regulation at all. This is particularly important as we have a great political divide on establish this framework for regulation. And this can be a more non-partisan issue rather than a political one. So based on these comments and actually using from the proto-organizer role here, if I can make a question for the whole panel is how can we better articulate maybe ex-ante regulation, ex-post regulation based on antitrust, and how these issues can be better framed in developing remedies here. But thank you, Nicolo. Thank you for your space and rush a little bit with the presentation.
No, thank you. That was fantastic, Artur. We have put a link to this white paper also in the YouTube chat. And yeah, I think it's an ongoing conversation where, as you emphasize, the importance of third parties' participation is crucial. And we hope to see this dialogue continuing with the approach that has been taken so far in the Brazilian ecosystem. So you have kindly already anticipated what I was going to do, that is say, basically how we can coordinate ex-ante and ex-post. That's kind of a question for everybody to reflect upon as we are drawing to a close. And there are no questions from Slido, but maybe we can end up with our final consideration, each of us, wrapping up and reflecting on this point and raising anything else that you want to raise for the others. I mean, I would go probably then in the order that we have just followed, but Artur has just raised his own question, and I think the wrapping up remarks are already very accurate and useful. So I would go actually in reverse order. So starting from Artur, then going back to Ian, if he has anything to that he wants to add on this question, or anything take home from this discussion, which is just there is so much that we could discuss. We're just highlighting some points, and we will continue the discussion in future occasions. Just want to mention here in November we will have the Opens Forum Academy Summit that will discuss a lot of interoperability question, and we also have the BRICS Plus Digital Competition Forum. So this will be spaces for us to continue the discussion, as well as many other initiatives, I'm sure. But if you want to offer some final reflections after what we've heard, that would be very welcome. So starting from you, Ian.
Sorry, I wasn't clear about the order. As you said, I could say many things, but I will just highlight one issue, which I think is so critical. And today was great for this. Your November events are great for this. Maybe I can make it over. We'll see. It was Bruno. Thanks for picking out the relevant market studies from the French and the Dutch Competition Authority. There's such a treasure trove, these market studies from all the different jurisdictions. I know the UK one's best for obvious reasons. I referred so often, Simonetta and Isa will remember, in the last 5 years that we have been a civil society lobbying for a stronger DMA to the UK's digital markets market study that was published in 2020. It's so long and detailed. I could only, even as an academic, I only had time to properly read and understand all of it because I was effectively given a grant by the Open Society Foundations to spend 6 months reading it. I mean, it's really quite unbelievable how much is in there, and in the Vestager so-called Three Wise Men report. Great that Brazil has produced this. Its own study. Absolutely, this stuff needs to be adapted to local conditions. That's important. So in competition policy terms, we do not want homogenization. We don't want Me Too products. I think it was Isa made that point. I think that's an important one about social media. It's important about ex-ante regulation as well. We don't want a Brussels effect where the DMA is cloned around the world, because it wouldn't work outside the EU. Obviously, every democracy has its own specificities that need to be dealt with. So I think market studies and other forms of information, shared, coordinated. Obviously, the national regulatory authorities do quite a good job at picking topics that, separating out their efforts. So someone covers one area, France and the Netherlands covered cloud. The UK actually, sorry, I'm contradicting myself already. The UK has done endless market studies on the cloud ecosystem, and still has not put them into effect. It's rather frustrating. And a reminder that ex-ante regimes are not a panacea for all sorts of reasons, obviously. And I hope they don't turn it, I hope in 10 years, we aren't saying it's the new Intel. Why is it, why 10 years later have we still not seen enforcement of all of this excellent analysis and research and evidence gathered by the NRAs? Apple, with a straight face yesterday, claimed that I checked, Apple market capitalization yesterday was $2.2 trillion. It almost touched $4 trillion last year. It is a world historically valuable company. And with a straight face, it told the European Commission workshop yesterday it could not afford to implement all of the technical specification details that Simonetta has highlighted, which, as I pointed out in Slido, was absolutely absurd. And obviously, Apple is not stupid. They don't believe it. I'm just stunned they thought anyone else would just not roll on the floor laughing when they make these kind of simplistic points. Let's please have a sophisticated debate with the gatekeepers. They have enough resources to go head to head with NRAs and the European Parliament and the United States Congress and the Brazilian Supreme Court, as you know. And ultimately, if they disagree with how the European Commission is enforcing the DMA, yes, they spent half of yesterday's workshop wasting time telling us, I'm sorry, Europe democratically decided in 2022 between its elected parliament and its elected heads of government and their representatives in the Council of the European Union what the DMA was going to say. It's not for Apple to say our interpretation is different. I'm sorry, I find that profoundly offensive to the rule of law and to democracy. Full stop. Great that Nico mentioned open source, and that's the last reference I'll make back. Is that's another way governments can coordinate, fund the production of digital public infrastructure, open source libraries that they can all build on. France and Germany have just done this with a Office suite replacement, which I think is a great example of a way forward.
Fantastic, thank you. Now I realized actually Bruno should have been earlier in the order, you're right. So Bruno, sorry for skipping you. Do you want to offer your reflections? Wrapping up.
Yeah, sure, just to wrap up, I think we just need to keep fostering this forum of discussions, having the transatlantic dialogue. We in Brazil, we often just receive the inputs from the other side of the pond, and I think nowadays we are getting the same step and being able to offer solutions as well. And as Simonetta and Ian have put, I think we have the ability to filter what Europe has done, or the UK has done, and then maybe develop our own solutions here, and not just do a legal transplant of what has happening and learn what has worked and what has not, but be conscient that we have been able to develop our own solutions that have tackled the problems to our reality. And I think we are just benefiting from all the inputs and the discussion going worldwide, the international fora, and so on. And just to congratulate Nicola again on putting this together. And always great to hear from the panelists.
Thank you. And we are just getting started. This event and also Brazil more generally in regulating these markets. So, well, then I think Maria Luisa is the next.
Thank you. And indeed, thank you for organizing this. And I'm happy to hear we are just at the beginning. 2 points, really. So the first one is on the substance. We started with Fernanda telling us interoperability is mentioned in never increasing number of regulations. Just 2 hours of this webinar have shown that not only is how many times or in how many regulatory framework is mentioned, but also is how it is mentioned, which kind of interoperability. In 2 hours, we have already pointed out vertical, horizontal, semantic, equitable. And we have mentioned a lot of possible goals with the sort of safeguard and the highlighting that Jan made for all of us, which is is a technical tool that is difficult to shape in a proper way, but this shouldn't be a red line, shouldn't discourage us, and it can be used to achieve a variety of goals. And this, I think, is something that is starting to resonate also for a number of regulators. And I think it lands very well in also more coordination between ex ante and ex post. We shouldn't be discouraged by the fact that we can use interoperability for different purposes. Actually, this is an advantage, probably. It's not a disadvantage. And I'm not calling for being overambitious. I'm just calling for being a little bit more looking at reality for what it is, and this convergence that we see in the market, and try to think about convergence in remedies and goals as well. The other point that I wanted to make is probably also in line with how is it ever possible that some big tech they can still say some things and get along with that. I think partly is because there is still a huge asymmetry of information. And it's true that it's not as it was before. It's true that the regulators and the competition authorities should listen to the people that can provide a different understanding. I think things are moving there as well. You mentioned in market studies, they're an excellent tool. But I also think that positive inputs have come, or positive messages have come from the Apple decision that the European Commission has mentioned, because many times they've made reference to the feedback they have received by third parties. And for what I know, this is unprecedented. I've never seen this in a competition, a traditional competition decision that the European Commission has issued. So probably there is a perception that there is a sort of an epistemic problem, and then if we coordinate, we can rebalance this asymmetry of information. So I would say this is probably the way to go everywhere, definitely not just in Brussels.
Terrific, we agree. Simonetta, please.
Okay, thank you. Well, just briefly, a relationship between ex ante, ex post. What I'm seeing also now in the language of the judges dealing with the antitrust matters is increasingly language coming from the DMA. So I think it's very important that we have a regulation with provisions framed in the language of rights. Okay, so we have rights of business users, we have rights of end users, and I think this is extremely important. So I would recommend any legislator, despite the fact that perhaps enforcement is difficult, to have that type of language, because judges are going to pick it up, and that's incredibly important. Okay, then the another thing I would say, well, I'm very happy that the DMA is a very, very strong piece of legislation. I think it has not so many possibilities for gatekeepers to sort of exploit strange language or loopholes. That is extremely important. You really need a very, very important, very, very well-written piece of legislation with many, many tools. Okay, so one, we have seen specification decision out of the box, and then many others. It's not the end of the story. Provide as many tools as possible, not just one. Okay. So that's extremely important, I think. This is something that the EU legislator has done very nicely. And then sophistication. Sophistication. CAGE needs quite a lot of technological, technical sophistication. If you read those decisions, of course, during the compliance shops, they say things that perhaps they hope some journalists pick up. But then if you really read the decisions, you see the level of sophistication that the Commission has already achieved in terms of technical details, in terms of good legal arguments based on the interpretation of the DMA. So yes, it's quite a lot to ask from regulators, but this is key to, I think, something which is meaningful in the end.
Fantastic. No, we agree. We need to be sophisticated and build capacity. That's crucial. Now, then going directly to the authority, Victor, if you want to share your views on that.
Yeah, very fast. I agree with you that we are not dealing with a panacea through this ex-ante regulation. It seems to me that there is an institutional challenge, not only for the antitrust authority, but the whole design of institutional authorities, and also for this involvement of stakeholders in this process. But we cannot reproduce in the subject of ex-ante regulation the same problems of antitrust enforcement through ex-post. So insulation and the private power without multi-sectoral stakeholders and democratic participation. So I think we have like an opportunity to change and to rethink this design with a sociological view of the whole antitrust, using the digital or this thing about interoperability as a way for this whole thing. And in interoperability in this case is not just a technical requirement. I see it as a challenge, an institutional challenge, and we should discuss how mandates align, the agencies cooperate, the incentives, the timing of the decisions, so ex-ante and ex-post, this involvement of stakeholders and creating process that make it more normal to have stakeholders interacting with the antitrust authority. So I think these are the final remarks from my side. And congratulations, Nicolo, and thank you all for the discussion.
Thank you. And you revealed an aspect that I forgot to mention about this title. The title was Interoperability of Digital Platforms and its regulation. So the regulation of digital platforms around the world should also be interoperable, talk to each other, and take into account the spillover effects and so on. So that is particularly important. Then moving to the other authority, Javi, thank you very much for joining us. Please share your last considerations on this, if you can.
Yes, thank you again, Nicolo, for the invitation. And just really quickly, now we are moving to another part of our project that's going to be the discussions in Congress, since when the bill will be presented to Congress. And I think that the views of the experts here are all aligned with the views of the Minister of Finance. And I think that it's really important to bring these discussions to Congress. Congress has the opportunity to hear from experts from Brazil, and also eventually you are all invited from Europe to come to Brazil if you have the opportunity to discuss with our Congress our bill, and it will help also to improve our bill. Maybe we don't know how the discussions will go in Congress, but it's always an opportunity to improve or gaining from the experience from other countries.
Thank you for this invitation. Yes, we will try to facilitate that as well with our partners from civil society all around the world and experts that can chime in and help us strengthen the legal framework here and the success of this bill. Finally, then I'm gonna move back to Fernanda, to our research center, to a research project where everything started, where we started mapping out the different ex-ante regulations. Fernanda, want to offer a last thought on this?
Yes, I would like just first of all to thank you, Nicola, for this invitation. And I think this is we can see that this is a complex discussion, and it involves not only transatlantic context, but truly global context, as we try to demonstrate with the project. And I think the CTS will continue the research in these complexities in the near future. So thank you very much for the opportunity.
Yes, for sure we will continue. As I said, we are just getting started, and I really thank everybody who has joined us today. First of all, all the speakers, but also all those who attended the event online. And if we have piqued your interest, get in touch with us. We are happy to continue this discussion, which will take. Will take a long time. Will be a continuing conversation, and so we will be happy to host it and facilitate it, also facilitating the connection between different stakeholders in this process. So once again, thanks to everyone. We really appreciate your participation, and have a good rest of the day. See you soon.